You get hurt on the job. Maybe it was a slip on a wet deck, a piece of equipment that gave out, or something that had been broken for months and nobody fixed it. Under federal law, you have a right called maintenance and cure. Your employer owes you daily living expenses and full medical coverage while you recover. They send you a check. It's smaller than you expected. You're not sure if that's what you're supposed to be getting. And you don't want to make trouble before you know what the rules actually are. Here's what most injured offshore workers don't know. Under federal maritime law, your employer owes you something called maintenance and cure. It's one of the oldest legal protections in American maritime law, dating back centuries, and it requires your employer to pay your daily living expenses and your full medical care while you recover from an injury that happened in service of the vessel. No lawsuit required. No proof of fault required. It kicks in automatically the moment you're hurt. The problem is that most employers know you don't know exactly what you're entitled to, and they use that against you from day one. The daily rate they offer is almost never what the law actually requires. The medical care they direct you to is often controlled by their own physicians, and the moment they think they can cut it off, they do. By the time we're done here, you'll know exactly what maintenance and cure covers, what the daily rate is supposed to look like, and how employers push it below that. What maximum medical improvement actually means versus what your employers tell you it means. When cutting off your maintenance and cure becomes its own separate legal claim against them with punitive damages on the table, and how maintenance and cure fits alongside your other rights as a maritime worker. Maintenance. That is the daily living expenses portion. The idea is straightforward. When you're working as a seaman, the vessel is essentially your home while you're working. You eat aboard, you sleep aboard, the employer provides the basics of daily life. When you're injured and you can no longer work, the law says your employer still has to cover those baseline living costs. Maintenance is designed to cover your food and your housing while you can recover. The fight over maintenance almost always comes down to the daily rate. Courts have established the rate must be reasonable, but for decades, employers have pushed that number as low as they can. Some employers still offer very low daily rates, sometimes in the $20 to $40 range or lower. Courts do not apply a single universal number. The rate should be tied to your documented reasonable food and lodging expenses, and if the number your employer is offering does not cover your actual cost, that number is worth challenging. Cure is the medical care portion. Your employer is obligated to pay for your medical treatment, doctor's visits, surgery, physical therapy prescriptions, diagnostics, specialist referrals, and anything else reasonably related to your injury, until you reach what the law calls maximum medical improvement, or MMI. MMI is the legal and medical standard for when your condition has stabilized to the point where further treatment is unlikely to improve it further. That's the end point, not when the employer has paid what they budgeted, not when an arbitrary number of weeks has elapsed. The MMI improvement problem. In practice, MMI is whatever the employer's physician says it is, and the employer's physician has a financial relationship with the employer. Maritime companies often maintain long-standing referral relationships with specific medical clinics or physicians. These clinics receive consistent business from the employer. The seaman goes in for appointments, and weeks later, the physician declares MMI. Benefits cut, claim closed. Meanwhile, the seaman cannot get up in the morning without significant pain and cannot return to the physical work his job requires. You have the right to seek your own medical evaluation from a physician of your choosing, someone with no financial relationship to your employer. That independent medical opinion can be used to challenge the company's doctor's finding. When that opinion conflicts with the company's physician's conclusion, as it often does in cases where the company's physician has declared premature MMI, that conflict is powerful evidence that termination of your benefits was premature and unlawful. The law distinguishes between an employer who terminates maintenance and cure based on reasonable medical evidence and an employer who cuts it off as a pressure tactic. When an employer willfully and wantonly denies maintenance and cure or terminates it without reasonable medical jurisdiction, courts can award punitive damages. Not just the benefits you are owed, but additional damages designed to punish deliberately harmful conduct and deter employers from making the same calculation with the next injured worker. In cases where the employer's refusal to pay was callous or in bad faith, courts can also award your attorney's fees on top of that. If your maintenance and cure has already been cut off or reduced, that is a separate and urgent situation. We cover exactly what to do in the M&C Cutoff video on this channel. Maintenance and cure does not replace your Jones Act negligence claim or your unseaworthiness claim against the vessel owner. These run on separate, simultaneous tracks. Your employer who suggests that accepting maintenance and cure payments means you are giving up your right to pursue your other claim is not telling you the truth. All three can move at the same time, and a maritime attorney will pursue all three on your behalf. Here's a concrete example of how they run together. Say you were injured when a piece of cargo handling equipment failed on a vessel that should have been inspected and maintained. Your employer starts paying maintenance, covering your daily expenses and directing you to their clinic. At the same time, your attorney is building the Jones Act negligence case around the employer's failure to maintain that equipment and the unseaworthiness claim based on the defective condition of the vessel itself. The maintenance and cure payments keep you housed and receiving medical care while the negligence case develops. One does not pause or waive the other. There are independent legal obligations that exist simultaneously from the day of your injury. Some employers and their insurance carriers try to steer injured seamen onto state workers' compensation instead of paying maintenance and cure under federal maritime law. Workers' comp was not designed for seamen. It provides far less than federal maritime law gives you, and in some situations, accepting you can complicate your ability to pursue Jones Act claims you're actually entitled to. If your maintenance and cure is being underpaid or disputed, get your own attorney. Do not wait for the dispute to resolve itself. Second, get your own physician. An independent medical opinion about your current condition and the ongoing medical treatment is the most important documentation you can have. Third, write down every communication you have with your employer and their insurer about your maintenance and cure. Date it, save the letters. If someone calls you, note who called, what they said, and when. Fourth, do not sign anything your employer or their insurance company sends you without having a maritime lawyer review it first. Insurance correspondence that comes after a dispute or reduction frequently includes language designed to limit your future options in ways that are not obvious to someone who hasn't seen these documents before. Fifth, keep a personal log of your symptoms, your ongoing treatment needs, and how your injury is affecting your daily life. That record, kept consistently over time, becomes important evidence of the actual impact of your injury and the ongoing care you require. Before you accept anything from your employer or sign anything they send you, watch the workers' comp video on this channel. Companies use workers' comp to cut off your maintenance and cure rights, and the difference between those two systems can mean the difference between a fair recovery and walking away with almost nothing. And before you talk to your employer or their doctor about any of this, that is a video on the most dangerous things you can say to your employer and their medical team after a maritime injury. One wrong sentence at the wrong moment can be used against you for the life of your claim. Watch that one before your next conversation with anyone on the employer's side. If you have questions about your specific situation, we handle these cases on a contingency fee basis. You pay nothing unless we recover for you. Contact information is in the description. What's your situation? Have you been told your maintenance cure was ending sooner than you expected? Drop it in the comments and I'll do my best to point you in the right direction.